SJC-11905, Roland Van Liew v. Colleen Stansfield.
Good morning, Mr. Fencer.
Good morning, Your Honors. Michael Fencer for the appellant, Colleen Stansfield. Your Honor, we're here on an appeal of a dismissal of a two-count complaint filed in the district court that was dismissed by the motion judge in the district court pursuant to Chapter 231, Section 59H, the anti-SLAPP statute. The plaintiff appealed that order in the district court, which reversed the trial court's order and remanded the case for trial. After a full hearing, as I said, the trial court was reversed. Thereafter, Ms. Stansfield took this further interlocutory appeal pursuant to the authority of Faber v. Walton. Your Honor, there were some jurisdictional questions raised that in the request for amicus briefs that I was unaware that any were filed, but I thought that I would address them. Specifically, the jurisdictional questions that were raised are whether or not a case that is dismissed in the district court under a special motion to dismiss should go to the appellate division or if it should go directly to the appeals court as articulated in Faber v. Walton. The second question was whether or not if the appeal is to the appellate division, which then reverses the order, as is the case here, whether the defendant should have a right to a further interlocutory review in the appeals court. Your Honors, I would suggest that both of these questions, while not explicit, have already been answered in this court's decision in Faber v. Walton. As early as 1998 in the Duracraft decision, when this court first took up one of the earlier decisions under Section 59H, this court recognized and acknowledged that the legislative intent behind Section 59H was to immunize parties from claims based on petitioning activities. That same principle was articulated in Faber v. Walton. In Faber, that was a case that involved a special motion to dismiss after the obtaining of a 209A order, similar to what happened here with the protective order was issued under a newer statute, Chapter 258E, outside of the domestic sphere. But there, this court analyzed the policies behind the traditional rule of finality for an appeal, taking into account that the denial of the special motion to dismiss would be an interlocutory order, and analyzed the application of the present execution doctrine in the anti-SLAPP context. It also, in doing so, cited the decision of this court in Brum v. Dartmouth, which was a governmental immunity suit raised under the Tort Claims Act. And the court recognized that the immunity granted under Section 59H to an anti-SLAPP litigant, or any litigant with immunity for that matter, like governmental immunity, would be lost forever if the denial of a special motion to dismiss was not appealable until the close of litigation, which would ordinarily be the course. Since the legislative purpose of protecting litigants or immunizing them from claims based on petitioning would go unfulfilled without a right to interlocutory review, the Faber court specifically held that there is a right to an interlocutory appellate review from the denial of a special motion to dismiss under the anti-SLAPP statute. Regardless of the path that was followed here, Ms. Stansfield stands in the precise spot as that the Faber court described. She is a defendant in a case that alleges abuse of process and malicious prosecution, the only two counts in the complaint.
But at the time of the, at the time of the district court, she didn't stand in the same position because she'd won, right?
That's correct, Your Honor, but I'm going to suggest to the court that it doesn't matter that she lost in front of the motion judge or in the appellate division. The reality is that the district court denied her special motion to dismiss.
Well, yes, but it was only the appellate division that did, so, and she would have an appeal anyway, right?
Well, that was one of the questions raised in the amicus solicitation, Your Honor, and I wanted to address it.
Oh, you would say, oh, yeah, okay. She wouldn't actually, because it would have to be remanded for trial. So you're,
Exactly.
so are you saying then that where, take what happened in the district court happened, then Mr. Van Liew should have gone right to the appeals court. That's what would happen?
That is Ms. Stansfield's position, and I believe that that is what Faber instructs. And the reason for that...
And that's what happened here, isn't it?
No, Your Honor.
It went to the
It went from the district court in front of the motion judge in the district court to the appellate division of the district court.
Oh, okay. But then it went to the appeals court.
Well, no, it didn't, Your Honor.
I thought we took...
We did.
It was taken on this court's own initiative, but I did file an appeal in the appeals court for Ms. Stansfield.
But I think your point is, but for some change in the rules, ordinarily, take Andy Slapp out of this, if a party if there's a case that the appellate division says, reverse what the district court did, remand for trial, before you could appeal that, ordinarily, you have to go to trial and then appeal.
In the traditional sense,
Yes.
the order of the appellate division was not a final order.
Right.
Because it restored the claims and remanded them for trial. That's correct.
So this would be, even though, obviously, Mr. Van Liew is not in the position that Fabre was, or Walton, whichever, I forget, for purposes of uniformity, you would say skip the appellate division, go right to the appeals court.
That's correct, Your Honor. I mean, the Faber court made a point of saying that one of the purposes of the decision was certainty, uniformity in treatment of litigants, and a consistent development of the body of law. One might initially, at first blush, say, well, why disrupt typical process? And I think that there are a couple of good reasons to do that and to apply Faber here. One is that if you leave the district court and go to the appellate division, there are 4 appellate divisions, including the BMC's appellate division. And in my experience, they are not bound to follow each other. It appears that they make some effort sometime, but when there's a disagreement from one division to another, and I'm not positive myself that courts within the same division are bound by their own decisions. Here, that is not going, if you have 4 divisions, like the Northern Division that decided this, articulating decisions, I would suggest that it's going to be very difficult to develop a consistent body of law in this area.
Can I just ask, procedurally, so are you saying that at the district court level, whoever lost, which was not you at that point?
That's correct.
You won at that point, so
Yes.
you wouldn't have done the appeal.
I'm sorry?
You would not have done the appeal. It would have been Mr. Van Liew who would have had to have
Yes,
appealed.
when we won the special motion, we didn't want to appeal. Mr. Van Liew had a right to appeal because that was a final order as to his case.
And so you're saying that the appeal should not have gone to the appellate division, it should have gone to the appeals court, but there's certainly nothing under the rules that suggests that that should have happened.
No, that's correct, Your Honor.
So it would be a question of us changing.
It would be expanding Faber, actually,
Yeah.
is what I'm advocating.
But essentially following the same tract that Faber created.
That's correct, Your Honor.
Fabre.
And essentially, the way, if I were to craft the holding for the court, if I were so invited, is that on a decision of any trial court, regardless in the district court or the superior court, I mean, the superior court's going to go to the appeals court anyway.
But arguably, you could track Fabre more closely if you just, instead of, in your case, you get to appeal as opposed to having to go to trial. I mean, wouldn't that be a direct track?
It would if it went to the appeals court. What I'm suggesting is that it should have gone to the appeals court first anyways, both so that the law can be developed consistently and so that the anti-SLAPP defendant can get the full protection of the immunity by avoiding that one stage of appeal.
Yeah. Could you shift to the merits of the case?
I can, Your Honor. Thank you. Your Honor, Mr. Van Liew has, in his briefs, attempted to make this a political freedom of speech case,
Well,
much like
isn't
we
it?
were just hearing.
Isn't it?
Other than one incident, Your Honor, actually 2 incidents, I would suggest no. The 2 incidents out of the 4 in which Ms. Stansfield complained to the trial court was abusive conduct of Mr. Van Liew. where their very first encounter on the telephone was she
She
called.
called him up.
She did. She called to get to know him.
She could have hung him up, and
Yeah.
instead of 2 hours on the phone, she could have hung up any time.
That's correct, Your Honor. She could have. She didn't. She took 2 hours of what she has characterized to me as abuse, and in her affidavit, that's how she characterizes it. But that's absolutely correct. The second incident that is not patently or arguably political, Your Honor, occurred in a political forum, but was not political speech. At the meet and greet, which occurred on February 1, 2012, one of the statements that Mr. Van Liew made to Ms. Stansfield was he accused her of giving an anonymous letter to his wife, one that I've never seen myself, but they accused him of being a pedophile. And then he told her, "I'm coming after you." Even though those statements were made in a political environment, Your Honors, those are the kind of true threats that O'Brien carves out. And Ms. Stansfield didn't sit down and read O'Brien, which notably was only issued the day before the meet and greet. She went to the police station. She told the police what happened. The police advised her that she could go to the court and seek a protection order. They gave their opinion that it might be difficult. She went to the district court. She spoke to the staff there and described to them what had happened. And they gave her the paperwork, and they assisted her in getting in front of a judge.
So what's the third incident?
Yeah.
There were two other incidents, Your Honor, that are, in my opinion, more clearly political than others. Ms. Stansfield is a planning board member, and Mr. Van Liew has published mailings to the town calling her corrupt and a liar.
Where in that email does he say that she is a liar?
I have not seen these mailings, Your Honor.
But it's an exhibit, isn't it? It's a 5-page email.
No, that was a separate open letter that also called her corrupt and a liar. But he has sent.
Well, where does it call her a liar in that email?
In that open letter, I don't know that it does.
Yeah, and where in that letter does it call her corrupt?
I'm not sure that it does, Your Honor.
Yeah.
She
drew a conclusion about them.
No, she emoted, or she stated in her affidavit that she had seen these mailings herself, and that she was called the corrupt and a liar.
Even if it did say that, I mean, that's political speech, isn't it?
It is, Your Honor, but we have to take into account.
What's the threatening part about it?
So is the other statement that he made during the recall election, that she was corrupt and a liar. But Ms. Stansfield was not trained to deal with the esoterica, the dividing line that you and I are discussing right now between protected speech.
Yeah, but we're talking about whether, I mean, she may not be trained, but that doesn't mean that it's necessarily going to qualify.
That's true, but she had two out of 4 incidents that she left shaken and disturbed. She considered them to be cruel and hostile, and she went to court. And on the day on February 1, when this man accused her of giving her a letter, giving an anonymous letter to her wife, she drew an immediate conclusion that everything before was personal. And she immediately formed a fear for her own safety and the safety of her 3 young children. The other piece of this, Your Honor, that I want to point out, and I see I'm running a little short on time, is that in order for Mr. Van Liew to succeed in defeating the special motion here, they must show that Ms. Stansfield had actual malice towards Mr. Van Liew. The record is devoid of evidence of her malice. She has none. She's a political person herself. She appreciates the process. She doesn't agree with everything Mr. Van Liew stands for, but she appreciates the exchange. Mr. Van Liew would be required to show that no reasonable person could conclude that Ms. Stansfield had a legal or a factual basis to seek that protective order.
Can I understand, she got the protective order, ex parte, and then went in and got it amended, also ex parte?
There was an amendment because she was concerned that Mr. Van Liew was going to
continue to say things publicly about her?
He was
continue to say things publicly about her?
On a television show, that's correct.
So the restraining order, as amended, did what? It barred him from speaking about her, mentioning her name?
I believe it did, Your Honor.
Okay.
But the proper focus today here, Your Honor, I would suggest, is the very day that she went and got the restraining order on February 1.
Because that's the petitioning
That's
activity.
the petitioning act that was that gave rise to this complaint. And those are that is the state of her mind at that time.
But the amendment, when she got the amendment, I mean, doesn't that give some insight into what she was trying to do, which was essentially silencing?
It may, Your
Middle of
Honor.
a campaign.
But you'd have to draw an inference to do that. And the case law, under the anti-SLAPP statute and under the malicious prosecution and abuse of process, say that malice must be affirmatively proven, and it can't be done by inference.
All right, thank you.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, my name is Karen Pickett, and I represent the plaintiff appellee, Roland Van Liew. Approximately 4 years ago, in February of 2012, my client was actively campaigning for a position on the Chelmsford Board of Selectmen. He called a meet and greet at the library, at the Chelmsford Library, where I believe 6 citizens attended, and it was also attended by Ms. Stansfield. There is a dispute about what happened at the end of the meet and greet. Ms. Stansfield said that my client said, "I'm coming for you" or "after you." My client denies that, and that there's 2 affidavits that were presented in the district court, I believe of an elderly married couple who were standing there at the time and said that what Ms. Stansfield averred in her affidavit was not true.
So this all goes to whether, obviously, to whether she really did go to court on February 1 or whatever the date was to get the 258E order for any purpose. She was truly petitioning or just trying to get back at him more.
Well, I believe under the anti-SLAPP statute, we have the burden of showing that there was no reasonable basis in fact or law for her to go to do that. And I believe Ms. Stansfield's counsel has conceded that at best he can argue 2 situations that were not pure political speech. One, a years-old telephone conversation where they were debating politics, and I believe in her affidavit she said that he called her stupid and an idiot.
But you're not suggesting that there had, or are you, that in order for, that she would have to show that she was entitled to a 258E order? Or are you suggesting that?
Well, I'm suggesting that she'd have to have reasonable basis in the law or facts to support that. And just by simply reading the statute alone, or in the papers that she filled out, said that you have to show us 3 instances of conduct that rises to the level of harassment. And as Your Honors know in O'Brien, harassment doesn't just mean, I don't like you, you're corrupt, you're a liar. It means that you have to be placed in fear of physical harm or damage to your property, and there has to be 3 instances, all of which have that intent. And so the coming to court today and saying, I don't know the law, I mean, it seems ludicrous, frankly, in light of the fact that she's a public official, right?
But the problem is the judge allowed the order. Can we find that it's devoid of reasonable factual support or legal basis where Judge Brennan not only allowed the order, but then allowed the amendment that Justice Cordy made reference to?
Well, I believe, Your Honor, there's case law that says that it's understandable in the context of getting restraining orders or these new 258E orders, that people are coming in distressed and it's an ex parte nature. But you'd have to look and see what Ms. Stansfield told Judge Brennan initially. She never said that she was a public official. And she was really just describing one instance, and she said she was in fear of her life. You also have to look at the fact that as the evidence has developed, there's a police report where she told the police officers that she was going in to get to this, that she had attended that meet and greet to rattle my client's cage. That's not somebody who's in fear of physical injury or property damage. The second thing, and Justice Cordy brought this up, is I think when days later she goes back and petitions again and asks the court to modify the order to say that he cannot speak about me anywhere, well, he's running a political campaign is extremely problematic. You know, Your Honors, I cited to the Weld for Governor campaign case in my brief. But Your Honors even more recently decided that Commonwealth v. Lucas case, which basically says that political speech, especially in the context of a campaign, is vital to our Constitution and to our society. And so this is exactly what was going on. My client was running a campaign. His political opponent didn't like what she was saying about him. She ran into court, got an ex parte order, and then if you look at the full hearing on that Judge Cremins did, my client didn't even have to testify. The woman came forward. The judge gave her plenty of time to come forward with all the evidence that she had that my client had done something to harass her. And as you can see from the full hearing, Judge Cremins said, "I'm sorry, Ms. Stansfield. This is political speech, and this is what you signed up for. This is the rough and tumble of becoming a politician." But in the meantime, my client had been essentially under a gag order.
For how long was that?
I believe the initial order was February 1st. It was vacated on February 15th. On February 6th, it was modified. He had a scheduled cable program that he had to cancel because...
Did he win the campaign?
He lost the campaign, yes. But I don't think he's claiming damages for that. That would be problematic, probably.
Could be an asset.
Yeah, I don't know why people get involved. My father was a local politician, and I would never encourage anyone to do it. But
Yeah, we're discovering it's apparently a tough work.
it
these
is. It's
days.
tough work. It's tough work. And so I do believe that the malice is present when you see exactly what kind of relief she was trying to get, which was to shut down political speech, and also because, as Your Honor has pointed out, she was she made the call to my client, didn't like what he had to say, and hung up years before. She didn't like that he was publishing things about her that she disagreed with. Well, that's the nature of the beast. And she herself admitted, according to the police officer who wrote the report, that she went to confront my client and to rattle his cages. And so, if my client, I believe in the anti-SLAPP case, Benoit, Justice Cordy said that the anti-SLAPP statute doesn't eliminate malicious prosecution in abusive process cases. If it did, it would be constitutionally problematic because under Article 11 of our Constitution, each person who's suffered harm is entitled to seek legal redress. And in this case, the harm is particularly severe because it affected my client's First Amendment and campaign rights, but also affected his reputation. I mean, it was broadcast that this anti-harassment order entered against him. Those are very, very strong charges. It's sometimes worse than a criminal charge, as Your Honors have recognized.
Now, let me ask you a question about there's a 5-page email in the record. And I take it that she actually relied upon that as one of the 4 incidents because she read it into the record at a hearing.
She read it into the record, but I believe I'm not sure I'm not sure if that email is in the record. There's other email exchanges that are there. I'm happy to look and match those up, Your Honor. But
well, there's a 5-page email that is in the record on appeal that we have.
Right. Yes.
And if you look at the transcript of the hearing, the hearing where both parties were present, she read that
email
into the record.
And I don't believe that it does say that she's corrupt or a liar. In that, but I'd have to read the email again. I'm sorry, I haven't done that.
Right.
But even so, I mean, that's obviously political speech that she can't try to suppress as a public official.
And going back to my earlier question, do you know of any case in which we have found that something was devoid of legal merit that a judge had granted? I mean, have we done that before?
I believe there might be a appeals court unpublished decision that I found, Your Honor, which basically said you really can't put too much stock in a non-adversarial process because, frankly, anyone can go to court for anything, and she can go, and if she was lying about something,
right, well, that's what I guess that's my next question: is does it depend upon what was actually told to the judge, or if the person spoke accurately and presented all the facts, and the judge made a determination, would that protect it from being viewed to be devoid, or must we find that there was something concealed from the judge or misstated to the judge?
As Your Honor knows, sometimes judges. As we all know, because when we do appellate work, sometimes judges get it wrong, and she heard what she had to say, but if anyone sat in a busy district court, if someone comes in and says, I'm concerned, the judge is going to give her an order, but it doesn't mean the judge is, pulling out the statute and making sure that there's 3 threats. That's the obligation of the plaintiff to do.
You think that judges actually are sitting there not knowing the law and what the obligations are, and don't take seriously when people come in with 209As or 258As?
Oh, I believe they absolutely do, Your Honor, but...
Including at the initial stage.
But you have to realize 258 is also a new statute, and, if someone came in and said that they were concerned, there's nothing in the record that says that Judge Brennan found 3 instances of, malicious conduct.
Counsel, maybe you can point me to this, because I'm not quite sure whether I've seen it or not. Is there a record of what went on in the ex parte proceeding?
There is, Your Honor, yes. It's attached, it was attached in Mr. Fencer's appendix.
Okay.
There's a full record of the ex parte hearing.
Okay.
Both of them?
Yeah.
And not the one on the motion for modification.
Right.
There's a water right by you,
Thank you, Your Honor.
the other side.
Both sides.
No, right there. No, turn around,
Oh,
right there.
I'm sorry. That's very sickly. Thank you.
Okay.
And I believe it's towards the back of the
I got it.
appendix.
I had read Judge Crimmins, but I hadn't noticed where this proceeding was. Thank you, I have it now. So we have a full record of what was before the judge on the ex parte.
On the initial ex parte, but
Great,
not on the
thank you.
modification.
And what happened with the modification? Was that,
The modification was granted.
was also ex parte?
It was also ex parte.
And there's no record of it?
There's a record of what she applied for.
That's in the record?
That's in the record.
Was it Judge Brennan again?
It's hard to tell from the signature. I'm not sure, Your Honor.
Now, when the full hearing was conducted, the hearing at which both parties were present, I take it it involved the same 4 incidents upon which Mrs. Stansfield obtained the original ex parte order, but the details were fleshed out in considerably more detail.
She testified, read from that email. I believe she talked about the phone call. She did mention an incident after the initial order was entered where she said that he had published something about her that was unfavorable. So that was included. And there was testimony about what happened at the meet and greet.
But the initial proceeding, this is a 4-page transcript.
Yes, Your Honor, it's very
nothing.
brief. Yeah, very brief. And clearly in the initial hearing, there's no description of 3 harassing events. Clearly there's not. Would Your Honor like me to address the procedural question?
Sure.
Okay. So we're sort of in this weird arena where I researched and really couldn't find an answer to the question.
Well, do you oppose Mr. Fencer's suggestion?
I believe that the case really should have been sent back to the district court for trial after the appellate division decided.
But this would jump over the appellate division. What he's suggesting is that when you got dismissed in the district court, you should have been able to go right to the appeals court.
Yes, although frankly, under the statute, I wouldn't have been able to go.
No, I
Right,
understand
no,
that,
if
but
we're
it would
talking
be a
about future.
change
In the future, yes. Well, we're already here now, so. And it's, as you can imagine, it's been an expensive process to have to go to the appellate division because that's what the statute requires, and now we're up here.
But do you oppose the suggestion that you be able to go directly to a person in your client's position, be able to go directly to the appeals court?
I don't particularly have a position on it, Your Honor, because I'm here now, obviously, so it won't benefit my client one way or the other. But one thing I would say about the position that we're in here now is, and I do appreciate the direction in favor, but as you know, the specific holding in favor is that when a anti-SLAPP motion is denied in the district court, there's a right to interlocutory review. Obviously, under 231, Section 109, there's only a right to seek review in the appeals court in limited circumstances, which wouldn't have been present here. And so, in fairness to Mr. Van Liew and other plaintiffs who find themselves in their position, it doesn't seem really fair that they have to go to the appellate division, and then the person who's not happy with the appellate division can take it up to the appeals court. One reason I think that you may not want to extend Faber, and this is obviously your decision, not mine, is that, as I understood Faber, however it's called, the reason the court came up with that, or one of the reasons the court came up with that, is because the anti-SLAPP statute was a relatively new statute that had been enacted in, I think, in the late 1990s. And so Faber was decided in 2002, and this court said we want a consistent body of law, whether the case originated in the Superior Court or in the District Court. And I would suggest that since Faber was decided, and unfortunately I've probably read all the cases, there's been dozens and dozens and dozens of cases on the application of the anti-SLAPP statute. And it really is, it's a clear legal standard that was applied by the appellate division in our case, that looked at the entire record and found that Ms. Stansfield did not show that she had a reasonable basis or fact in law to pursue the relief, the anti-harassment relief, and to modify that relief, and that caused great harm to my client. So I think that may be one reason why Faber doesn't need to be extended, but I will leave that to the courts.
All right, thank you.
Thank you very much.